الحمد لله رب العالمين، والصلاة والسلام على سيدنا محمد النبي الطاهر الأمين وعلى آله وصحبه والتابعين. على بركة الله نبدأ الجلسة الثانية التي هي بعنوان الاتجاهات الحديثة في ممارسات مؤسسات تسوية المنازعات. We will start the session 2, New Trends in Practice of ADR Institution. Allow me to call the chairman, Mr. Éireik, the speakers, Mr. Andrea Cavares, Dr. Hassan Arab, Dr. Kevin Nash, Dr. Mustafa Abdul Ghaffar, and Mr. Jose Angelo and Mr. Ziad Al-Khushaim kindly to come to the stage.
Well, welcome back. And this morning we were talking about the evolution of arbitral institutions, how they format, the different efforts that are required to give them credibility. And we're really going to move on from that and talk about some more specific issues related to institutions, trends at a more general level, but also some more technical issues and practice-related issues. Our first speaker today is Andrea Cavares. He will be speaking about the limits of party autonomy in institutional arbitration. As somebody who obviously is associated with an institution, I find this topic to be particularly interesting, and some of the demands, frankly, that are placed on institutions also relate to issues of our authority over an arbitration. Andrea is a partner at Bonelli Reed. I'm going to let you pronounce that the correct way. An adjunct professor at Sciences Po Law School in Paris. He most recently, prior to that, was Secretary General of the ICC International Court of Arbitration and Director of the ICC's Dispute Resolution Services. He's on the board of various organizations, an author, and somebody well known, of course, to the international arbitrator community.
Assalamu alaikum and good afternoon, everyone. Let me spend 20 seconds of my 10 minutes to congratulate SCCA and the organizers for putting together this excellent program and for thanking them very much for letting me be part of it. The topic I will address today is one that I think is crucial to institutional arbitration. So I thought it was particularly appropriate in an event which launches the creation of a new institution. The limits of party autonomy. We all know that international arbitration, including institutional arbitration, is the realm of party autonomy. The parties are largely free to agree on all aspects of the process. But the questions we are asking today is, are there limits to party autonomy? I have myself identified two sets of limits. One I will only mention today. We don't have time to go into the details, but is what I would describe as the outer limits of party autonomy. Since the selection of arbitration rules and of an institution to administer those rules is an expression of party autonomy, the parties, through this agreement, cannot achieve more than they could by a specific ad hoc agreement, which means they cannot violate overriding mandatory rules of law or public policy. And there have been cases in several jurisdictions, including arbitration-friendly jurisdictions, in which arbitration rules or the way arbitration rules are applied by institutions or by arbitrators have been considered to be in breach of public policy or mandatory rules of law. And these were breaches of fundamental principles of law, such as the equality of the parties in the process, non-discrimination, the right of access to justice, particularly with respect to impecunious parties, arbitrators' independence and impartiality, and the arbitral institutions and the arbitrators' immunity from civil liability. And this has led, in a few cases, to the setting aside or to the refusal of the enforcement of arbitral awards. But what I would like to focus my remarks today is rather a second set of limits to party autonomy that I would describe as the inner limits to party autonomy. And this is what happens when the parties refer to arbitration rules and so incorporate the arbitration rules into their agreement to arbitrate, but at the same time they also exercise party autonomy in a second way by entering into specific agreements, possibly integrating, amending, or derogating from the selected arbitration rules. Now, I must say at the outset that conflicts between arbitration rules and the specific agreements of the parties are quite rare in practice, and this mainly for two reasons. The first reason is that arbitration rules are not detailed codes of civil procedure. They are succinct sets of rules which set out fundamental principles with respect to the conduct of the proceedings, but are extremely flexible, and so leave room for the exercise of party autonomy within, permitted by the rules themselves. And the second reason why these conflicts between arbitration rules and the parties' specific stipulations are quite rare in practice is that the parties' specific agreement tends to prevail as lex specialis, precisely because the parties have specifically agreed to those. We should not lose sight of the contractual nature of institutional arbitration. And I'm not talking here about the contract between the parties, but I'm talking about the contract the parties on the one hand and the arbitral institution on the other hand enter into when the rules of the institution are adopted. Which means that if the parties purport to modify or amend the rules, this is a modification of the offer of services by the institution, and the institution remains free to refuse to administer the proceedings. Now, I think that all arbitral institutions have provisions of their rules that they wouldn't accept derogation from, fundamental rules considered fundamental by the institution, but I would submit that there is some lack of clarity by institutions themselves as to which provisions of their rules indeed can be considered as mandatory or as part of the so-called institutional public policy. And I'm here using the terms mandatory and public policy as misnomers in a way, because of course we are not talking of rules of law, but we are talking about an expression of party autonomy. The rules have a contractual value and not the value of the law. So what I've tried to do is to try to identify the provisions of institutional rules, or rather the criteria that may help in identifying institutional rules, provisions, that the institutions would not accept derogations from. And first of all, I must say that this may be different from an institution to institution. Each institution considers certain provisions of its rules as fundamentals. I've identified three criteria for identifying precisely what provisions can be considered as non-subject to derogation. There are provisions contained in institutional rules whose express terms exclude amendment. Second, there are provisions that reflect essential features of the arbitral process under that rule. And third, there are provisions which can be considered as part of the institutional public policy because they're aimed as protecting fundamental principles of public policy and mandatory rules of law. I have a few examples. You will forgive me if these examples come from the ICC rules, the rules of the International Chamber of Commerce I'm most familiar with, and with respect to which there is a lot of practice and of case law. Starting from the first category, which are provisions whose express terms exclude amendment, an example can be found in Appendix 3 to the ICC rules. This is Article 2.4, which provides that the arbitrator's fees and expenses shall be fixed exclusively by the court, the ICC Court of Arbitration, as required by the rules, separate fee arrangements between the parties and the arbitrator are contrary to the rules. So the provision in this case could not be clearer. It envisages the possibility of separate agreements between the parties and excludes these separate agreements categorically. Another example can be found in what is now Article 1.2 and 6.2 of the ICC rules, which provide that the court, again, the ICC Court of Arbitration, is the only body authorized to administer arbitration under the rules. And that by agreeing to arbitration under the rules, the ICC rules, the parties have accepted that the arbitration shall be administered by the court. These were amendments that were introduced into the ICC rules in 2012 to clarify that only the ICC court can administer the ICC rules. This responds to an issue of policy, of course. Rules are tailored to an institution, so it would not be advisable for the parties to have the rules of an institution administered by a different institution, but it is now also expressed very clearly in the rules, which means that arbitrators and institutions who want to apply the rules chosen by the parties also have to apply these specific provisions and therefore abstain for administering arbitrations under the rules of the ICC or of other institutions that have adopted similar rules. Let's move on to the second category, provisions that reflect essential features of the rules. Again, as everybody knows, under the ICC rules, a very specific feature is the scrutiny by the institution of draft awards before these awards are finalized by the arbitrators and notified to the parties. Other institutions perform similar functions under the rules, but probably no institution does this in the way the ICC does. Therefore, the institution, the ICC, would not accept an arbitration agreement where the parties tend to exclude this provision, precisely because this makes the ICC rules recognizable and different from any other sets of rules. Another example, always belonging to the same categories, essential features of the rules, is the provisions with respect to the screening of requests for arbitration by the ICC court. Again, this cannot be excluded. In this respect, I would also like to point out that what we call institutional public policy is an evolving notion, because it may change in time. What an institution considers as fundamental at a given point in time may, in a subsequent version of its rules, not have the same nature. And this applies, for example, to the terms of reference under the ICC rules or to the communication of reasons for the institution's administrative decision. In the past, these were considered fundamental principles of the ICC rules. In the more recent versions of the rules, they've lost this nature. And finally, the third category I mentioned, provisions aimed at safeguarding public policy and mandatory rules of law. This applies, for example, to the role of institution in appointing or confirming arbitrators under their rules. There is a French case, Samson Kimonda case, where French courts have recognized that the institution's refusal to administer proceedings in a case where the parties had excluded the ICC provisions with respect to the role of the institution in confirming or appointing arbitrators, as well as also the role of the institution in screening or in scrutinizing awards, was a legitimate refusal by the institution. And another example is Article 12.8 of the ICC rules, which is appointment of arbitral tribunals in multi-party arbitration. This is the provision that allows the institution to appoint all members of the tribunal in a multi-party scenario to avoid the risk of an imbalance or of inequality between the parties with respect to the constitution of the tribunal. My conclusions are that institutional rules are drafted by bodies of arbitration specialists, so they are thoroughly thought through. They are based on the institution's experience and practice in administering numerous arbitrations. Therefore, the parties should be very careful in amending or modifying the rules. When the parties introduce modification to the rules, this should only be in cases where this responds to parties' genuine needs. Our lawyers tend to be creative. They want to change also what has been drafted by an institution. I would submit that it is generally not advisable. And my last point would be that institutions should not be too differential to party autonomy. There are situations in which party autonomy probably doesn't deserve to be respected in all cases, particularly when this would be against the parties' interests themselves, particularly because this may lead to an unworkable arbitral process, and I've given some examples in the little time available, or in certain cases, particularly when the amendments go against express terms of the arbitration rules, this may lead to invalid or unenforceable awards. Thank you very much.
Next, we will be moving to Dr. Hassan Arab, who will be speaking about recent case management techniques, something that I think everybody that is in the arbitration field is hearing about more recently is issues of time and cost. And we will be hearing about matters related to that.
Well, thank you, Eric. Assalamu alaikum wa rahmatullahi wa barakatuh. Good afternoon, ladies and gentlemen. As mentioned by Eric, my presentation basically will be limited to the recent trends by the international arbitration institutions in terms of the case management. A study actually conducted, let me just turn the, so I'm waiting for the slide actually, but let me carry on actually. A study conducted by the Corporate Council International Arbitration Group showed that 100% of the Corporate Council that have participated in the survey believe that arbitration takes too long and costs too much. Another actually survey conducted by the Another survey conducted in 2015 by Queen Mary University and Whiten Case. The respondent on that survey, around 66% of the they believe that arbitration is costly, and around 36% of the people who participated, they believe that there is a lack of speed in arbitration. There has been a recent notable trend, both at the legislative level as well as the institution level, adopted time and cost-effective measure. Most and major arbitration institutions have extended effort in recent years in order to introduce rules to regulate the cost and time, placing a duty on the parties, including the tribunal, to conduct arbitration in timely and cost-effective manner, providing arbitral tribunal, and depending on the circumstances, with the necessary powers to issue case management decisions to conduct the arbitration in the manner it considers appropriate. And the obvious example is Article 14 of the LCIA rules of 2014, as well as Article 17 of the UNISTRAL rules of 2010. Some examples of the case management techniques used by the arbitral tribunal are, for example, dividing the key issue and rendering one or more partial awards. And by this technique, basically, it will lead the parties sometimes to settle the dispute when they will realize that the partial award is against them, or there is a trend that it will be against them in the future. In a large and complex cases, it is useful and efficient to divide the proceedings. For instance, to decide on the issue of liability prior to entertaining the amount of the damage. However, from the enforcement point of view, the issue of liability, from the enforcement point of view, this could create a problem. And here actually I mentioned a decision issued by Dubai Court of Cassation. And the purpose to highlight this decision is not to criticize the courts. As a practitioner, actually, I learned a lot, and I do believe that the courts in UAE, and in particular Dubai, actually, they are friendly to a large extent with the arbitration. But here to show basically that even though if you have a modern arbitration law and a modern arbitration rules by the institution, if you will not get the support by the judiciary, there is no any benefit you can get, because end of the day, the beneficiary basically they will monitor. So in the decision, or the two decisions I highlighted here in my presentation, there was a partial award issued by a sole arbitrator, and the arbitration was seated in London under the rules of the LAMM, the London Maritime Arbitration Association. It was about the lease agreement of a vessel. So the sole arbitrator decided to issue a partial arbitration award about the lease, the lease period amount, and later on, basically, he will decide on another award about the compensation. When the claimant took the partial award to the Dubai Court of Cassation, to recognize and get the enforcement, the respondent approached the court as well to ask the court to refuse recognition and enforcement of the partial award based on a point related to the domestic law. The point was basically, he raised the point that the person who signed the arbitration agreement doesn't have the capacity to represent the respondent. The court of first instance, basically, they ignored this challenge and they decided to recognize the award. The same thing he appealed the decision, and the Court of Appeal, they accept to recognize the award. Then he approached the Court of Cassation, which is the highest court. He raised the challenge of the lack of capacity under the UAE companies law. The Court of Cassation basically highlighted a very good point, that the challenge of raised by the respondent to refuse recognition of the award based on the lack of capacity should consider the law of the sea under the New York Convention and not the local law. And this is very good award. But the strange thing, after a while, when the claimant had the second award on the compensation, he approached the court again to get the recognition. And the respondent approached the court with the same challenge about the capacity. Unfortunately, the Court of Cassation, with some other judges, they decided to refuse the recognition based on the lack of capacity of the person who signed the arbitration award based on the domestic award, which is contradict with the other award. So we had two contradiction award. The partial award was recognized, and the final award, it's been refused to be recognized. So this is one of the issues, actually. It's good to have the case management. It's good to have a modern legislative, but at the same time, you need the court to support these provisions. The other technique is emphasize on the use of technology. For example, hearing may be conducted through modern means of communication, where attendance in person is not essential. And we have basically Article 21.3 of SCA rules. We have Article 33.3 of the UAE, the recent UAE arbitration law, confirming the same meaning. Relying on documents only, Article 24.7 of the SCA confirming this meaning as well. In cases where the issue to be decided is based on the documents rather than through oral evidence. ICC also, expedited procedure rules have the same meaning. And we had the incident basically recently with the ICC. Okay, it's fine. Actually, we had a recent case with the ICC under the new rule of the expedited procedure rule. The claim amount was very less, and at the first conference call between the ICC Secretariat and the parties, they managed to convince the parties to amend their agreement. Instead of having 3 arbitrators, to have a sole arbitrator. Then basically the council themselves, they decided to educate their clients to have the expedited rules rather than the normal rules of the ICC. And it shows actually, this case give a good example of how basically the ICC Secretariat are very proactive in terms of educating the parties about the techniques which will reduce the cost and time. I have actually lots of things about the case management pre-hearing conference. For example, the documents, relying on the documents rather than the hearing. The expert opinion, for example, sometimes it leads to a long process and cost, while we have some rules through the different arbitration institutions encourage the parties basically to reduce unnecessary and repetition and the documents and the expert opinion, to have basically a joint expert opinion rather than different expert reports, limiting the length and the scope of written submission to avoid repetition. Several arbitral institutions provided guidelines for the production of documents, of documentary evidence to reduce time and cost. Due to the time also, I would recommend you to go through the slides. I highlighted some of the articles under the different arbitration institutions. For example, Article 22.1 and 2 of the ICC, Article 10, 20, and 21 of SCA arbitration rules. It's very useful to go through it, and it supports the case management in order to reduce the cost and the time. In the UNISTRAL rules of 2010, we will find Article 17.1, and finally, Article 14.1 of the DIFC LCIA. This is overview about the case management and the trend used by the international arbitration centers to control the cost and time. And I'll be more than happy to answer any question after the panel. Thank you so much.
Thank you, Hassan. I should have mentioned that Hassan is he's co-head of litigation at Al Tamimi & Company. His practice includes a range of matters: civil, commercial, litigation, arbitration. He's served as an arbitrator and has experience in that respect as well. Moving on next to Kevin Nash, speaking about interim emergency measures, something, again, that institutionally we're seeing increasingly quite a bit of activity. We were talking just before the program today, and each institution really sees a number of parties coming in. They know that they have an arbitration agreement, but getting an arbitration tribunal that they can agree upon according to the applicable rules will always take a little bit of time. And we've got now emergency procedures that can take care of something where the party needs relief imminently. Kevin is Deputy Registrar and Center Director at the Singapore International Arbitration Center. He's overseen quite numbers of hundreds of arbitrations in that time, and is involved in rules drafting initiatives as well, including the revisions to the 2013 SEAC rules and the development of the SEAC investment arbitration rules. Kevin?
Thank you, Eric. Thank you to SCCA and the organizers. It is a real privilege to be here on behalf of SIC and Singapore. I will be discussing the emerging use of emergency interim measures in institutional arbitration and perhaps complementary institutional tools for dealing with other situations of urgency. It is perhaps appropriate to be accompanied by Andrea Calaveras, who of course was the former Secretary General of ICC. It was ICC that started this conversation in 1990 with the introduction of the pre-arbitral referee. Our chair, Éireach Tuckman from AAA ICDR, ICDR really gave us the modern conception of an emergency arbitrator in 2006, so the first institution to introduce this proper emergency arbitrator. Institutions, as institutions often do, followed the Stockholm Chamber of Commerce in 2010, Singapore International Arbitration Center in 2010, ICC in 2012, HKIC in 2013, LCIA in 2014. And you can see how the institutions work together, whether directly or indirectly, to continue to update and refine these procedures. I was just traveling in from Beijing. SIC is now conducting academies, so we were training young professionals in China on the use of emergency arbitration, expedited procedure, and early dismissal. And I think it's actually quite timely because the Beijing Arbitration Commission is the first mainland Chinese institution to have an emergency arbitrator order enforced. This order was taken to Hong Kong. So this emergency arbitrator procedure, at its core, what it is a mechanism to preserve the status quo prior to the constitution of the tribunal. And if you look at it, absent this procedure for the appointment of an emergency arbitrator, parties are really left with two options. A party could wait for the constitution of the tribunal, subject to the urgency of the case. This may work with a sole arbitrator tribunal, if that sole arbitrator can get up quickly. And in fact, there could be tactical reasons for taking it to a sole arbitrator, if you can get the sole arbitrator quickly. Because really, these emergency arbitrator orders are holding orders. This is going to be re-looked at by the tribunal when constituted. It may be modified and vacated. So it could work in a sole arbitrator tribunal. But with a very urgent case with a three-member tribunal, it's unlikely that you can get a three-member tribunal constituted in time. And so that's where the appointment of an emergency arbitrator comes in. So the parties have the option first to wait for the constitution of the tribunal, and the second is to apply to the competent court. This could be the seat court, the curial court, or it could be the court where the enforcement or really the effect of the emergency arbitrator order is sought. And there's perfectly good reasons for going to court, and if you look at most of the institutional rules on emergency arbitration, great pains are taken to ensure that these emergency arbitrator provisions are not incompatible with an application to court. So for instance, if a party needed an order against a third party, a non-signatory to the arbitration agreement, an emergency arbitrator, just like a tribunal, without those powers of imperium, it might make sense to go to the court. It could be the case that you need ex parte relief. So save for the Swiss chambers, all of the sets of institutional rules require notice to be given to the other parties. So if you needed that ex parte relief, application to the court makes sense again. Or really if confidentiality is not an issue. But these emergency arbitrator provisions, when you're looking at it from a court provision, philosophically, parties that have agreed to arbitration to immediately have to go off to court to get urgent interim relief really is not what the arbitral process is about. You may also be in a foreign court. There could be neutrality issues. The standard for the grant of interim relief that might be granted by the court could be different than an emergency arbitrator. So in SIC arbitrations, SIC emergency arbitrators tend to use what is now almost the transnational test, really drawn from American cyanamide and its progeny. So you're looking at a good arguable case, irreparable harm, urgency, balance of convenience. So the test could be different as well. You also have a potential lack of speed and the possibility of an appellate process in court. So the emergency arbitrator provision really has kind of changed the landscape for arbitration by allowing parties that have agreed to arbitration to stay within the arbitral process. So looking at SIC, SIC was the first Asian institution to introduce the emergency arbitrator provisions. We have had 83 applications since this provision was introduced in 2010. I was speaking with Éireck before the panel. ICDR has had 91. Andrea indicated that ICC has had around 100. So this is an enormous amount of applications. What's very interesting about what's happened in Singapore is that there has really become a culture and a certain amount of experience and nuance with these emergency arbitrator applications, because really having 83 of these in one jurisdiction. So the Secretariat has come to be much quicker and much more experienced with these emergency arbitrator applications, because there's a lot of different things that can happen during the course of an application. You could have a cross application. So a claimant files for the appointment of an emergency arbitrator. The respondent immediately files for a cross application. You might have a challenge to the appointment of the emergency arbitrator. This has to be done within 2 days of appointment, but you could have multiple challenges. SIC by rule issues reasoned decisions on challenges, so you have to be able to do that within the timing of this very urgent emergency arbitrator proceedings. Even something as simple as dealing with conflicts for arbitrators. Because at SIC, we appoint emergency arbitrators within 24 hours. You have to know which emergency arbitrators to approach. I think as a matter of practice across most institutions, you will approach emergency arbitrators on a provisional basis, see whether they're able to act, provide a provisional conflict list, and then if the president accepts the application, then you appoint the emergency arbitrator. Singapore is also unique because by law, the orders and awards of emergency arbitrators are enforceable as an order of the High Court in Singapore. Hong Kong is another jurisdiction that is provided for the enforceability of these emergency arbitrator orders, because that is ultimately the question with an emergency arbitrator order. If you have to take it to a different jurisdiction, can you have it enforced? SIC has had a good experience, particularly of late, in terms of how the courts are taking notice of SIC emergency arbitrator decisions. So the orders of an emergency arbitrator have been given effect in the Delhi High Court, Bombay High Court, and also in the District of Columbia. So not New York Convention enforceable, but courts are starting to give effect to these orders. SIC also included an opt-in provision in its SIC investment rules for the appointment of an emergency arbitrator. We are starting to see some jurisprudence coming from the Stockholm Chamber of Commerce for emergency arbitrators in treaty disputes, sometimes finding that they have jurisdiction even within a cooling off period. Emergency arbitrators are able to order broad types of interim disputes. We have seen a gag order, anti-suit injunctions, restraining a party from calling on a bank, guaranteed delivery up of documents, preservation of evidence. Most of these will be status quo injunctions. You will from time to time also see a mandatory injunction. The timelines, as I said, move very quickly. Emergency arbitrator appointed within 24 hours, 365 days of work a year. These applications almost always come in on Friday nights or the eve of a holiday. Usually a preliminary order, if there's a holding order required, will be issued within a few days, and the average time for the actual order is 8.5 days. There are also a few additional tools at SIC and other institutions if there's urgency on the merits. So SIC has an expedited procedure, a fast-track procedure where an award is made 6 months from the constitution of the tribunal. So if an award is needed on the merits within 6 months, a party could apply under the head of exceptional urgency for this expedited procedure. SIC is also the first commercial institution to introduce a provision for early dismissal of claims and defenses on the basis of manifest lack of legal merit or manifest lack of jurisdiction. This will allow parties, say in circumstances where the facts are not in dispute, but there's an urgent question of law, to get this decision at an early stage rather than having to wait for the full period of the arbitration. I guess the theme here really is that the institutions keep innovating, keep looking at what the other institutions are doing, and we keep getting better and better sets of rules. We see that with the SCCA rules. SIC has also taken another step for innovation. Our president, Gary Bourne, has introduced a proposal for the cross-institution consolidation of arbitrations. This will require institutions talking, keeping up a dialogue, and we're looking forward to keeping this dialogue going with the SCCA and all of the other institutions. Thank you, and I wish you all a successful conference.
Thank you, Kevin. Dr. Mustafa Abdel Ghaffar will be speaking about expedited procedures and emergency measures in arbitration. Again, a feature that we're seeing increasingly incorporated and developed as a part of an institution's practice.
Thank you, Mr. Chair. Bismillah ar-Rahman ar-Rahim. Bismillah wa salatu wa salam ala Rasulillah. Thank you so much. First of all, I would like, before introducing our new services, which are the expedited procedure and emergency arbitrator appendixes, I would like first of all to thank our partners in ICDR, AAA, for being so cooperative and supportive in helping us in drafting and reviewing the draft rules we have adopted as they usually were all the time. I would also like to thank so much one of the international experts that helped us a lot in drafting our rules, which is, fortunately, sitting in this panel, Mr. Andrea Carliveros, who worked also with us in drafting and revising. Also, thank you, Andrea. Thank you, Eric. Thank you so much for being so cooperative. I'll try to give the model in introducing the expedited procedure in such a very short time limit, being so expedited. The main features of the expedited procedure under, the new rules which came into force today are, these set of rules are applicable to cases, small cases under 4 million Saudi riyals. But also parties can have the options to opt in or opt out, which means that parties with cases that goes over 4 million Saudi riyal can opt in and agree mutually to adopt the expedited procedure. On the other hand, parties with cases under 4 million Saudi riyals, they can agree to opt out or not to apply expedited procedure or there's fast track and go to the normal track. What are the main features of the expedited procedure? Expedited procedure means to do it expedited, everybody should do his homework. The main feature of expedited procedure is the early intervention, which means that parties, the institutions, the arbitrator, everybody should do his homework properly and in due time. So the first feature of expedited procedures that require parties, both claimant and respondent, to submit their case with detailed submissions. That means that the claimant should file his notice of arbitration accompanied by all documents, all evidence he intended to rely on. Also, the defendant, the respondent should also submit his response with accompanied by all the documents and submissions he's intending to use in his case. Also, requests for production of documents should be very limited in scope and time. This is the first feature of the expedited procedure. In expedited procedure, we usually hold an early admin meeting, but this is optional, it's not necessary. We try to mediate the dispute. We try to resolve or to overcome any area of dispute on procedure aspect of the case. In expedited procedure, we have an expedited arbitrator appointment process, which means that we have a default system of sole arbitrator. If parties cannot agree on the arbitrator, the center will use the strike and rank method to appoint the arbitrator, but a limited strike and rank method, which means that parties have only limited ability to strike names. They can strike only up to 2 names from the list, the exchanged list. There is a short time limit or abbreviated time limits to return the lists so that we can push the process of appointment faster. In the proceeding phase, or the phase that the case was submitted to the tribunal should hold an early procedure conference, and issue a procedure order which determines the roadmap of the case, how the case will be handled throughout from the initiation until the final award. So this is what we call a concentrated approach of case management. So rather than having a piecemeal approach with separate hearings, no. I mean, since the first hearing, I mean, the tribunal determine how it will handle the case expeditiously. As for the award should be rendered within 2 time frames. 180 days, which means 6 months from the constitution of the tribunal, and no later than 30 days from the closure of hearing. As for the costs in the expedited procedure, we have provided for a reduced cost. So the costs of the admin costs is reduced by 20% from the normal track or according to the normal track of cases. As for the arbitrator fees, it's also reduced by 30% from the single arbitrator fees provided for in the rules. Speaking, I try to be very brief, as my colleague Kevin Nash speak about the features of the emergency arbitrator procedure, which is, I mean, similar feature exists in all over the world in all other institutions. We have in our rules, 2016 rules, a provision providing for emergency arbitrator to be appointed within 24 hours to handle any emergency relief or interim relief requested. What we adopt today is an appendix determining the procedure that we will adopt when handling such request from filing until the order or award of the emergency arbitrator. So the request should be accompanied with the notice of arbitration, or it may be submitted after the notice of arbitration. We provided in our rules for a brief procedure where we have to appoint the emergency arbitrator within 24 hours. In case there is a challenge, the challenge also should be decided within a very short time limit so that we start immediately the procedure. In the procedure of emergency arbitrator, the emergency arbitrator should issue a schedule, a procedure schedule within 48 hours, determining how he will handle the case. When adopting the award or order, he should make a kind of balance between, the interim relief requested and the harms that may result if he didn't decide to award such interim relief, balancing this with the harms that may result if he decided this for the other party or the respondent. Okay. So the order or award of emergency arbitrator is enforceable. There is no exhaustive list, there is no exclusive list of measures that can be adopted by the emergency arbitrator. But the emergency arbitrator, as I said, should take into consideration in his award to make this balance between the parties. The award should be, or order should be issued within a short time, 14 days from the transmission of file to the arbitrator. By this, thank you so much for listening, and if you have any questions, I'll be happy to respond. Thank you so much.
Thank you. And with respect to questions, we are going to leave some time at the end of the program. We'll open it up to the audience. Next is Jose Angelo Estrella Faria. Will speak about the importance of UNIDROIT in harmonizing international arbitration and developing national laws. So going from the very specific in terms of process to taking a step back. I will add, Jose is a senior legal officer and head of technical assistance unit at the Secretariat of the United Nations Commission on International Trade Law, UNCITRAL, of course, in Vienna, and prior to that was the Secretary General of the International Institute for the Unification of Private Affairs, which is UNIDROIT.
Thank you. Thank you very much, Eric, and allow me, like the speakers who preceded me, the use of the floor to thank SCCA for the perfect organization of this important event, for giving us the honor of being here and speaking to you today. The organizers proposed to me to address the impact of ancestral standards in promoting the harmonization of international arbitration, and that by nature would bring us to a different perspective and a slightly more general way of looking at international commercial arbitration in the context of this conference. The body I represent is a commission of the United Nations that reports to the UN General Assembly, and we may ask ourselves, what does the United Nations have to do with commercial law, and why is it concerned with commercial law? And the answer is very simple. We firmly believe that good commercial relations promote friendly relations and peace around the world, and that's why we have been involved in this for a very long time. The first involvement of the United Nations in arbitration is, as you know, the New York Convention of 1958 on the enforcement and recognition of foreign arbitral awards. Now, the starting point of this work is basically to fill the vacuum that still exists today, that caused by the absence of a multilateral mechanism for recognition and enforcement of court judgments. We trust foreign arbitral awards. The world still does not trust foreign court judgments. Now, international trade needs quick and effective settlement of disputes, and that's why you have an international mechanism for the enforcement of foreign arbitral awards through the New York Convention. This has also been followed by another important development, which is an increasing role of arbitration also for the settlement of domestic disputes. We've heard some reference to that in the opening panel this morning, the fact that the parties may choose arbitrators who have the required expertise for adjudicating the sometimes complex and very technical subject matter of the disputes that appear before them, concerns about the length of judicial proceedings, but also the flexibility that is given to the parties in choosing the institution, appointing the arbitrators, and also steering the proceedings, obviously within those limits that we heard in Andrea Carlivari's presentations. So this is why there's been a constant work on arbitration, which has not only remained at the New York Convention, moved on to follow work on the ancestral model law, international commercial arbitration, about which I'll say a few words in a minute. But let's just see this very quickly. These are figures from 2016, but these are figures of the ICC court. Only one that year, 966 cases filed, involving 3,000 parties from 137 jurisdictions. That's a very significant statement. I'm not adding here also the statistics of the AAA and other institutions, just to single out that one. Now, this is today's reality. But it was not long ago that very few countries had the capability of handling international cases. If you look back at the year the ancestral model law was adopted, 1985, there were only 65 institutions in 43 jurisdictions that were handling international commercial arbitration. And if you look at those groupings, you see that the vast majority was in Western Europe. Now, years passed since the adoption of the ancestral model law, 30 years after that. We have now 65 institutions countless institutions actually you have countless institutions in 126 countries that are capable of handling commercial arbitration, including international cases, also including Saudi Arabia, a country that was not present in that list years ago. This is a significant development, and one which we would also like to believe that has been also supported and promoted by the existence of an international legislative standard that was developed in a neutral process, counting with the participation of countries from all major legal systems at the various levels of development, as happened to be the case in the UN Commission on International Trade Law, UNCITRAL. Now, in doing this work, we have focused on the role of law to support arbitration proceedings. And then we look at it from two different levels, and you see that reflected in the model law. Arbitration involves also to some extent a very delicate dialogue between the arbitral tribunals and state courts. We heard also about that in the opening panel this morning, the remarks made by His Excellency the Minister of Justice of the Kingdom. The role of legislation is exactly to shape that relationship in a manner that the courts will support the arbitral proceedings and also not interfere with them in a manner that respects the party autonomy, the freedom that the parties express by choosing arbitration, which is also a point that was referred to by His Excellency the Minister of Commerce and Investment, and the role that arbitration plays in enhancing the investment climate in Saudi Arabia. So it is important for the law to set the limits by providing for the legal recognition of the arbitration agreement, for the non-interference with arbitration proceedings, and limiting the grounds for review of arbitration awards. At the same time, courts may support the arbitral proceedings not only by helping the constitution of the arbitral tribunal, but also by refraining from exercising jurisdictions when, in case where the parties have agreed to subject their disputes to arbitration, by providing assistance by issuing in the enforcement of interim measures issued by the arbitrators, and also enforcing the final award. I will not dwell on the development of the model law itself and the origins of purpose, but basically the idea was to offer the world a neutral standard that could inspire domestic legislation, and we do believe that we have achieved that goal. And it's based on these three essential pillars: the party autonomy to organize the proceedings that determine the applicable rules, the non-interference of state courts with the arbitration proceedings, and limited review by judicial courts of the arbitration awards. Those three principles, if you, at least the last two principles, if you will, find their original inspiration already in the New York Convention of 1958. Now, if you look at the status of application of the New York Convention, of the model law nowadays, the New York Convention itself already has 159 signatory states, which makes it the most successful commercial law instrument in the world. The model law is now, and there's a typo in that slide I note, nowadays has been enacted in 80 countries that represent 111 jurisdictions. If you consider that each province of Canada and Australia is a separate jurisdiction, as well as the special administrative regions of Hong Kong and Macau within China. Now, the model law by itself has become a standard for, and you can read these quotes in the slides that will be available to you, has become a standard for measuring the quality of a domestic system for international commercial arbitration, but also, according to studies by the World Bank, is regarded as a standard for foreign direct investment and promoting foreign direct investment in the country as one of the factors that promote confidence in the domestic investment. And this is why we're so happy to note that Saudi Arabia, and to count Saudi Arabia among the countries that with the 2012 Royal Decree have effectively enacted the ancestral model law. Dr. Ziad Khoshain, who would follow me, would certainly address more concretely the relationship between the domestic Saudi law and the ancestral model law, but we do consider that it is an enactment of the model law. And I would simply like to point out that not only the Saudi law limits interference by the judiciary, upholds party autonomy, but also upholds party autonomy in a particularly interesting way in that it allows the parties to choose as applicable law not only state law, but also through Article 5, to subject the relationship between them to provisions of any documents, model codes, or international conventions. So it doesn't necessarily have to be a treaty that is already in force in any particular country. That's a particularly modern way of looking at applicable law, and a particular liberal one. And we're certain that with events of this quality and more public awareness and training programs as SCCA is developing, these provisions would be applied in a manner that forces confidence in arbitration in Saudi Arabia. Thank you very much.
Thank you. And now we have Ziad Koshem, who's been there from the beginning, actually, with the SCCA. Will speak about recent practices in institutional arbitration in Saudi Arabia. Ziad is a managing partner at Koshem & Associates, full-service law firm here, practicing dispute resolution, corporate and M&A projects, etc. Also unique with respect to the fact that he is qualified in Saudi Arabia, New York, California, and Washington, D.C., an interesting mix.
Assalamu alaikum. Okay, so what I'm going to be discussing over the next 10 minutes will be a high-level overview of three things. Number one, the Saudi Arabian arbitration law. Number two, the enforcement law, which is very relevant in the context of discussing dispute resolution generally, to understand how enforcement of judgments are going to work in the kingdom. And number three, the Saudi Arabian Center for Commercial Arbitrations rules in relation to arbitration. So those are the three topics that I'll be discussing over the next 10 minutes. There's been a clear trend in Saudi Arabia over the past few years in relation to enhancing the effectiveness of dispute resolution. It started in 2012 when Saudi Arabia passed the new arbitration law, which was itself based on the UNCITRAL set of rules. Now, what did that law have to say? Well, it provided for greater flexibility to the parties to settle their disputes in a way that they deem fit. It allowed a rather robust process for the dispute to go through the process of arbitration, and allowed the parties the ability to have varying different languages to settle their disputes. And that is an important thing for international investors to be comfortable with usually the language of the relevant contract, which in the corporate world is usually English. It also allowed the parties, as we just heard from the team, the ability to agree substantive law other than Saudi law, so long, of course, as the award does not contravene Sharia principles. One of the things that the law also allowed is for the parties to agree for injunctive relief, but also it limited Saudi Arabian court supervision, whereas the previous arbitration law required that a court approve the terms of reference, approve the arbitrators themselves, and the arbitration agreement. That is no longer required under the arbitration law. So that was topic number one, the arbitration law. Topic number two, the enforcement court. In 2013, a new enforcement law was issued, and the enforcement law set up the enforcement court in Saudi Arabia. Enforcement court in Saudi Arabia is in charge of doing two things: enforcing court judgments and enforcing arbitral awards, both local and international. And this was a great development for settling disputes in Saudi Arabia, and essentially very good development for arbitration, because now there is a clear mechanism through which awards can be enforced in the kingdom. One of the things that the enforcement law did was it defined an arbitral award as an enforcement instrument. And together with the arbitration law, we clarified the contents of that enforcement instrument and what it needs to include. It also empowered the enforcement court to do multiple things. For example, it allowed the enforcement court to investigate assets of the respondent or the defendant, to freeze assets, and to ask the police to intervene. And this is something that a lot of international investors sometimes are not sure about or have a mixed message about, the enforcement court does not open up the case on its merits. The enforcement court only looks at the prima facie requirements of the enforcement instrument, namely the arbitral award, makes sure that it meets those requirements and applies it. The only thing that the enforcement court should do is verify that the award does not contravene Sharia principles. And this is again something that international investors sometimes are confused about, because they think that if a case is to be enforced in the kingdom, then a court is going to open the matter up on its merits, and that is not correct. All right, that was item number 2, the enforcement court. Let's move on to item number 3, which is to discuss the Saudi Center for Commercial Arbitration's rules. I was a founding member of the board, and really thanks to the executive team at the time and today, these rules that I'm going to highlight have become a fantastic development for institutional arbitration. Now, one thing that we should all remember is that the center was not the first institutional form of arbitration in the kingdom. The Saudi Arabian Chambers of Commerce have an institution through which disputes can be settled. But what the rules did was created a robust and clear way to fix those gaps where if the parties do not agree on various issues, those rules would then apply. So let's go ahead and go through those very high-level set of rules. Well, the first thing is the rules are rather flexible. And as everybody here knows, arbitration is a creature of contract, and the dispute itself and the process through which it follows is also a creature of agreement between the parties of the dispute. And that's what the rules do. The rules allow the parties to agree the place of arbitration, the language of the arbitration, how information is exchanged between the different parties, how witnesses are going to be presented. We all know that arbitration lives and dies by the quality of the arbitrators. And if the arbitrators are not skilled or are not experts in the relevant matter that is that is the subject matter of the dispute, the arbitration will most likely not going to proceed in the most effective of ways, despite what rules are going to be applied. Every once in a while, parties to a dispute will also dispute the appointment of a chairman of a 3-panel tribunal or a single arbitrator in a single member tribunal. So what happens if that happens under the rules? Well, as Dr. Mustafa mentioned, well, there is the concept of strike and the listing and striking method. One of the things that the rules do, and this is something that as an arbitrator I certainly appreciate, is to clarify that an arbitrator is not going to be liable for any act or omission in relation to the case that they're arbitrating, and they cannot be called as a witness down the line in relation to the case that they are adjudicating. One of the things that the rules also do is that they give the power to the tribunal itself to interpret the rules insofar as it relates to their powers. And the center interprets the rules as it relates to their powers. One of the things that we have all seen as both litigants and arbitrators and as judges is that the concept of impartiality and independence is a very important concept, and I'm glad that the rules had affirmed it, and not only something that must happen at the beginning of a arbitration, but on a continuous basis. The rules further explain, and this is something that I'm sure some of you in the audience know about. A few months ago, a Saudi court voided an arbitration award. Why did that court do that? It did that because it discovered that there was ex parte communication between one of the members of an arbitration and one of the parties. As I'm sure you know, that is something that should not happen, and I'm glad that the rules have set that as a prohibited activity and gave the center the ability to remove an arbitrator that violates the rules. One of the things that happens in arbitration is a significant debate as to whether notice has been provided, what is notice, and where notice is sent. The rules go on to also explain that notice is basically any document that allows a record of a transmission of the information under which it was transmitted, and also defines that delivery can be deemed if it's delivered at any of the locations noted in the rules. This is something that I'm sure the litigants, the litigators in this room here have suffered from time to time. Electronic notice is allowed, and one of the things that we were just actually debating just before we came into the stage here today is when arbitration actually starts, and the rules define arbitration to start at the moment that notice is delivered to the center. So what is a notice of arbitration? What does it include? What makes a notice of arbitration tick the box in relation to the commencement of arbitration? Well, the rules explain that it needs to include various pieces of information, such as the demand, the names of the claimants, identify the facts, and setting out essentially the basis of the claim, and of course the relevant contract. Now, who decides whether a notice of arbitration is in fact sufficient? It's the tribunal. And this is actually a very important thing because it allows the arbitration to continue. The reply from the respondent needs to include some basic information, which includes, of course, a assertion of lack of jurisdiction and a counterclaim if one was defined within that. One of the things that I've researched under Saudi law is the concept of privilege, and I'm glad to see that the rules actually set out that communications between the parties and their counsel are protected and subject to privilege. And of course, as one would want arbitration to be, it is confidential, hearings are private, and the awards are confidential. Overall, the arbitration under the rules allow for an organized nature of the arbitration, including having a 15-day hard notice for hearings, for the tribunal to explain what the contents of the hearing is about, and allows witness lists to be exchanged between the parties before the hearing takes place. One of the things that respondents oftentimes do is essentially choose not to attend a hearing, and sometimes even claimants abandon a case after it starts. The rules explain that that is not sufficient for the arbitration to continue. Every once in a while, a tribunal would need access to subject matter experts. This happens in construction cases, as I'm sure the audience knows. And the rules allow that to be the case and require that, of course, they be independent, allow the parties to discuss and exchange information about who's going to be coming and presenting, and allowing, of course, questioning of those experts. Finally, in terms of the award, as the enforcement law requires, the award must be in writing, must be issued within 60 days of the last hearing, and must be named as final and binding, and must be filed with the enforcement court. The obligation is on the tribunal to do so, and the parties must notify the tribunal of how and the process of that filing. As I mentioned before, in order for an award to be enforced in Saudi Arabia, it cannot contravene Sharia, but it can be subject to a law other than Saudi law. And the tribunal must, of course, apply the contract. To the extent that the contract is not clear, then the rules allow the usage of custom and practice. So, what I've discussed over the past 10 minutes was a brief overview of dispute resolution in the kingdom, how the arbitration law helped streamline arbitration in the kingdom generally and allowed the flexibility of institutional arbitration to spring up. We discussed the enforcement court and why that is an important development for the enforcement of court judgments and arbitral awards alike. And I took you through an overview of the Saudi Center rules. Thank you very much for listening, and I hope that we can engage in a good debate for the rest of the 2 days. Thank you.
Thank you, Ziad. So that covers the landscape in many respects with respect to institutional arbitration. We do have time for questions. This was planned. and we hope to get some of those from the audience. I understand there is a microphone out there. If you could raise your hand. Here.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Dr. Hurial Islami from Indonesia. I represent the government as we have this fund with the mandate to invest in Saudi. So the main purpose why we come here is very much to learn about the option for the dispute resolution, because we would like to adopt the proper one for our contracts, definitely. It's just that it's quite worrying when one of the speakers did mention about the process is usually quite lengthy and costly. So if I may, and since we also have the local expert here, first of all, of course, I would like to see you in person after this, if you don't mind. And secondly, based on your experience, is there any improvement? And what is the general situation here in Saudi when they adopt arbitration clause for dispute settlement resolution, in general as well as particularly with respect to investment in Saudi? Let's say if we would like to have contracts with the local companies with respect to investment, real estates, shares, for example, has the option to adopt arbitration as a method of dispute resolution has been effective, and has it been costly, and what is the average resolution time? Thank you very much.
Ziad, would you like to?
Thank you very much for that. So 3 parts to your question. First of all, do contracting parties use arbitration as a method of dispute resolution? The answer is yes. Quite a lot of our corporate teams' contracts, joint venture agreements, agency relationships, reseller relationships, license agreements for technology have arbitration clauses as a method for dispute resolution. Because the Saudi Center for Commercial Arbitration is new, the center has not been named in a lot of the contracts that we worked on as the institution through which a dispute in arbitration would be resolved. However, we've seen ICC, we've seen LCIA, and other different places for institutional arbitration. The second part of your question was, is it expensive? I would say that, again, arbitration is a creature of contract and a creature of agreements between the parties to the dispute. And so long as the counsel for both parties are reasonable and approach the case or the matter in dispute in a way that they would like to push away all the procedural aspects and focus mostly on the substance of the issues, I would say that actually arbitration can lead for a more efficient and a fast approach in resolving the dispute. Having said that, I would say that the Saudi courts are giving us a very good response time in relation to resolving disputes. I've actually started a couple of cases with my colleagues a year ago that ended actually before an arbitration that started around the same time. So the Saudi courts have become significantly more efficient than perhaps what you've learned about them in the past, including the enforcement court. An enforcement court has reacted very quickly in relation to the enforcement of arbitral awards, both domestic and international. So in terms of time, which was this last question that you had, the Saudi arbitration rules, law, requires that an arbitration finishes in 1 year, but allows the tribunal the ability to extend the case, the matter, for another 6 months on its own, and allows the parties, of course, to agree to extend for as long as they care to agree. In relation to the enforcement of arbitral awards through the enforcement court, my experience has been fantastic. We've enforced an award, we've actually received the enforcement deed in a span of a couple of months, and there was a enforcement dispute, نزاع تنفيذ, and that took, of course, its time, where there was a debate in relation to whether part of the award met the Sharia requirements or not, and we managed to succeed on that front as well. So I would think that foreign investors looking at Saudi Arabia need to reassess the court system as it exists today and the dispute resolution system as it exists today, looking at the arbitration law, the enforcement court, and the reform that has been happening really in the court system, and the investment that has occurred in the systems and the judges to date. And you'll find that to be really first class. Thank you.
Okay, another question. There were a few more. Number 2 over here. If I could just ask my own question or request, maybe just one question so that we have enough time to get through 1 or 2 more. Number 2? Somebody holding sign number 2? Yes?
Good afternoon. My name is John McGowan. I'm with Global Advocacy and Legal Counsel. Many thanks to the panel for the excellent presentations. My question is for Mr. Ziad, and perhaps other members of the panel can weigh in. I understand from the enforcement court will look at the question of Sharia principles, and I was wondering if you could just give us a few examples of how Sharia principles could be violated, perhaps in an award. One that comes to mind is interest, but if you could expound on that a bit.
I'm happy to. I don't want to monopolize the answers for the rest of the panel. Yes, so an enforcement court in Saudi Arabia needs to look at whether the award, the arbitral award, whether domestic or international, by the way, meets Sharia principles. One of the examples is interest. Now, one thing that's interesting about the enforcement law is that it explicitly states that the judge or the court needs to remove any offending part of the award. So, for example, if in fact the tribunal allowed the awarded interest as part of a dispute between parties, then the judge could actually just remove that component and enforce the remaining award. And so that is something that we've seen happen. And sometimes the dispute is not so clear as to whether it is interest or not. So for example, I was involved in a case that involved a sale, a deferred sale, a sale that had a deferred payment to it. And so the price of the deferred good was of course higher than the immediate price to be paid by the buyer. This is, according to a number of Sharia scholars, not a prohibited form of sale. The immediate sale of a good with a deferred payment that has a price that is higher than the immediate sales price. In that case, the other party to the dispute alleged that the matter had a interest as part of the award and wanted to invalidate the entire arbitral award. However, we managed to show the court and we managed to bring in Sharia scholars and experts that weighed in on the issue and explained that that is not a Sharia prohibited transaction. Other things include, for example, agreements to agree, option agreements, and other agreements that contain a high element of uncertainty, in Arabic, gharar. And those are the types of issues that would usually pop up in the discussions with the enforcement of arbitral awards. But the one thing that you need to be clear on, and in fact other international investors looking to invest in the kingdom or wanting to enforce their awards in the kingdom, is that the enforcement court is not a court that will review the case de novo or that will take a look at the merits of the case, unlike perhaps what you've been led to believe in previous discussions.
Thank you. One more, perhaps? Right here in the front.
So my question is to Mr. Ziad. It's concerning the restrictions imposed on, or the conditions that have to be met by lawyers in order to appear in front of arbitral tribunals. So the Saudi arbitration law sets conditions, clear conditions explicitly in the law, which is different than conditions to be met by judges, which surprisingly doesn't include nationality, religion, and the rest of the conditions, but it's not unclear with regard to lawyers. So are foreign lawyers, non-Muslim lawyers, allowed to participate in the arbitral procedures or not? The second question is, we understand that interests are prohibited in Sharia law, but it doesn't include banking, for example, in Saudi. Does that include liquidated damages as well? So the damages that are pre-calculated by the parties up front before the dispute arises. Thank you.
Mustafa, you want to provide your thoughts?
Okay, thank you, Mr. Chairman. Regarding the first question, the clear and brief answer, yes, non-Saudi lawyers, non-Muslim lawyers can appear before arbitral tribunals. There is no restriction whatsoever in this regard. As for the damages, I mean, you mentioned, I would say, if you are referring to the penalty clause, again, there is a kind of debate regarding whether a penalty clause can be enforced or can be considered as violating Sharia or not. But according to some recent decisions by the Supreme Council of Scholars, penalty clause can be enforced, can be considered as not violating Sharia if it is not, I mean, the original debt is not a sum of money. So if the obligation is not, I mean, monetary obligation, so penalty clause of damages, predefined damages can be enforced and can be considered as non-violating Sharia according to the Supreme Council of Scholars. Thank you.
Okay. And that concludes our panel discussion. Thank you all to our presenters. Very interesting discussion. And I think we are going to break for lunch.
Thank you, Mr. Chairman, and our distinguished guest speakers. Now we will have a break for lunch in Mosaic Restaurant, as well Asr prayer, and then inshallah ta'ala we'll resume with the session 3. سوف نتوقف الآن من أجل تناول طعام الغداء في صالة الموزايك، ومن ثم نعاود الجلسة الثالثة إن شاء الله تعالى التي ستبدأ بتمام الساعة 3. نرجو من الجميع الالتزام بالمواعيد كما عودتمونا طوال هذا اليوم، والسلام عليكم ورحمة الله وبركاته.